There are about 27,000 people in Massachusetts whose cases have been affected by faulty breath test results. It came to light recently that between 2011 and April of 2019, the results from the breath test machines that were being used by the police across the state of Massachusetts were unreliable. And so as a result, those cases that have been affected where there was a breath test reading and result ending in an OUI plea or conviction may be eligible for reopening. So you may have received a letter from the state saying that you're eligible to have a review of your case, or may be eligible to bring a motion to vacate the conviction in your case. We actually have done that. I and my firm have been successful in making that claim even before these letters came out. We were ahead of the curve following this development very closely. And what we've done in the past is argue to the court that a conviction or a guilty plea based on faulty breath test results is unconstitutional and should be overturned. It doesn't mean that your case is going to be automatically overturned. It means that you have to bring a motion to vacate. They are also known as motion for new trial or a motion to vacate the plea. And you have to argue to the judge that your plea or your conviction was based, at least in part, due to the breath test results in your case. In order to have your conviction set aside, you have to prove to the judge that your guilty plea or your continuance without a finding plea or your conviction after trial was based at least in part on the faulty breath test result. And if you can convince the judge, then that judge will allow you to reverse the conviction. It doesn't automatically mean your case will be dismissed. What it means is it puts you back in the position you were in before the case resolved, before the guilty verdict was announced, before you pleaded out to the case. So then it means that the prosecution has a right, if they choose, to re-prosecute you. So you have to be willing to still litigate the case. You have to be willing to go to trial if it takes that in order to pursue this motion to vacate the plea. Otherwise, it's all for nothing. And for those of you who are worried about the punishment, there is a presumption against being punished more harshly a second time around. What that means is if you've already served your sentence, you've already done probation, you've already done jail time, whatever it was, there's a presumption against being repunished or punished more harshly. If you've already served your sentence, what likely happens in the event of going through this process and then worst case scenario, being convicted again, you're very likely to just be given the same sentence you already had and then deemed served. Meaning that the worst that happens in most scenarios is that you would be back where you started from in the first place. That being said, before you do anything, it's always a good idea to contact a lawyer. And in fact, you should do this process with a lawyer if at all possible. And you should consult with a lawyer about any risks for the RMV, because even if you get the same punishment and it's deemed served so that the court is not punishing you any further, the new date of conviction or the new date of plea, if you then decide to re-plead out after reopening the case, could have an impact on your driver's license. And sometimes the RMV doesn't do what you think they would do based on a court order. Sometimes they do their own thing. And so it's possible that the RMV might look at this as another conviction, even though it's the first and the same conviction that you had in the first place, and they might resuspend your license. So it's always good to make sure that you understand the possibilities before you pursue a motion to vacate the plea.